Welcome, everyone. Thanks for joining us today for our webinar. My name is Rebecca Lee, and I'm joined by David Peloquin, a partner at Ropes and Gray. Today, we'll be talking about a really important topic, data sharing and talking about legal issues for countries of concern. And David has been focusing on this area for the last few years. I'll turn it over to David. If you could, as we go along, put your questions in the Q&A, that would be very helpful. If you have specific other technical questions, you can put those in the chat. So there's a chat at the bottom, and then you'll also see a Q&A. So as we go through, we will be answering your questions at the end. So please do put your questions in the Q&A box, and David will be answering them at the end of his talk. So I'll turn it over directly to David, who will be kicking us off and talking about these legal developments. Thank you so much, David, for joining us today.
Thanks very much, Rebecca. It's been a real pleasure to work with you and your team at Vivli for the last 7 years or so. I'm pleased to be here today to talk about some recent developments. They're all proposed developments. I'm going to say that at the top. Everything I'm talking about today is proposed. It's not finalized. But there have been several important developments in the last month or so, both on the executive front from the Biden administration and activity in Congress that have potential impacts on the sharing of data from the United States with China and other countries of concern. I'm going to make two preliminary comments here at the top before I get into the deck. One is, some of you might remember that about a year ago in April 2023, my law partner, Catherine Wong, and I did a presentation for Vivli, the same forum, where we talked about restrictions on cross-border data sharing from the European Union under the General Data Protection Regulation, or GDPR, and restrictions under China's data privacy laws, the PIPL and the HGRA limitations on genomic data sharing. At the time, we talked about how those countries have chosen to limit the sharing of personal data and genomic data from their country to most of the rest of the world, unless their country has determined a foreign country to have adequate data protection. At the time, we said the US didn't really have those types of limitations. What we have now seen in the last month is a proposal for the United States to develop limitations on sharing of certain types of sensitive data and with certain countries, most notably the People's Republic of China, but also some other countries of concern. So the US approach in a way is a more tailored one of saying, we'll have restrictions, but they're going to be restrictions on very specific types of data and sharing those types of data with countries that the United States sees as having a national security threat to the United States. The second thing that I wanted to make clear at the top is that while we're talking about restrictions on data sharing, the types of proposed regulations and proposed legislation I'm going to talk about today are really coming from grounding in national security and a concern with the national security of the United States and the view that the national security of the United States is being threatened by certain countries of concern. So while these laws implicate data sharing, sharing of personal data, they're not traditional privacy legislation that's really grounded in individual rights. And I think that's important to keep in mind if you're considering commenting on some of these proposed regulations, because in formulating your comments, you have to keep in mind that what the government is concerned about here is national security. And so certain solutions that we sometimes talk about under privacy laws, like individual consent, where we're saying an individual's rights are protected because they provided consent, that might be less persuasive here in this context, where people are focused on the national security of the United States. So I just wanted to level set with that at the beginning, that this is really something focused on national security, and we're having these limitations or proposed limitations on data sharing coming out of concerns about national security. If we go to our next slide here, I'm going to just give some background on what I'll be talking about today. So as I mentioned, in the last month and a half or so, the Biden administration and Congress have been focused on restricting transactions and data transfers in certain types of contracts with the People's Republic of China, which I will abbreviate the PRC throughout the presentation, and certain other countries of concern like Russia and Iran. I'm going to focus today on going through 3 of these recent developments. The first is President Biden's executive order on bulk sensitive personal data transfers, which was issued on February 28th, and the corresponding United States Department of Justice Advanced Notice of Proposed Rulemaking, or ANPRM, which was issued that same day. I'm then going to turn from the executive to two pieces of legislation that have been moving through Congress. One is the unanimous passage by the U.S. House of Representatives of the Protecting Americans' Data from Foreign Adversaries Act. That took place in March, so just a month ago. And the passage of the BIOSECURE Act, another piece of proposed legislation, by a critical Senate committee. And that took place in early March, so just over a month ago. All three of these developments are proposed, but if finalized, they would have important impacts on the sharing of data and biospecimens with the PRC and certain other jurisdictions that have been labeled as countries of concern. So first, I'm going to go through the executive order. I'm going to then talk about the DOJ ANPRM, then this Protecting Americans' Data from Foreign Adversaries Act, the BIOSECURE Act, and sum up with a few final thoughts. So turning to the executive order, as I mentioned on February 28th of this year, President Biden issued this executive order entitled Preventing Access to Americans' Bulk Sensitive Personal Data and United States Government-Related Data by Countries of Concern. So that's quite a mouthful, and there's a lot of defined terms in there that we're going to spend some time digging through today, like what is bulk sensitive personal data, what are countries of concern. What did this executive order do? So this was the White House directing the administrative agencies of the United States to take certain action. So perhaps most notably, the White House directed the U.S. Department of Justice, the DOJ, to promulgate regulations that restrict or prohibit transactions involving certain bulk sensitive personal data or United States government-related data and countries of concern or covered persons. Who are these countries of concern? Well, the executive order and the DOJ regulations initially identify as countries of concern the PRC, and notably this includes explicitly Hong Kong and Macau, which I think is done under a recognition that the PRC government in Beijing increasingly has control over those territories. Also identified are Russia, Iran, North Korea, Cuba, and Venezuela. So we can see countries that the US has historically thought pose a national security risk to the United States. But the restrictions don't only extend to the government of those countries. The restrictions also apply to entities that are owned by, controlled by, or subject to the jurisdiction or direction of a country of concern. And they would also apply to foreign persons who are employees or contractors of these entities or a country of concern, and foreign persons primarily resident in the territorial jurisdiction of a country of concern. And I'm going to go through some more detailed definitions here that the DOJ has given us about who are these covered persons. But this is just an overview of what the executive order has said. Also important to note here is that while the DOJ rulemaking, the proposed rule has already come out, and I'm going to spend quite a bit of time talking about that today, that is not the only thing the executive order called for. In this order, President Biden also directed the U.S. Department of Defense, the Department of Health and Human Services, the Veterans Administration, and the National Science Foundation to consider issuing their own regulations, guidance, or orders to prohibit the provision of assistance. That would mean like prohibiting providing a federal grant or contract to somebody if that assistance would enable access by countries of concern or covered persons to U.S. persons' bulk sensitive personal data, including personal health and human genomic data. So the bottom line is here, while the DOJ has put out some proposed rules I'm going to talk about today, those rules are not going to apply to, let's say, government-funded research that is funded by the Department of Health and Human Services, like an NIH grant. Rather, it's most likely that HHS will issue its own regulations, its own guidance that would govern that government-funded research. So just keep that in mind. In a way, I think this is helpful because the government is trying to coordinate amongst the agencies so that we don't have duplicative regulation where the same activity is subject to different sets of regulations. But this is an important thing to keep in mind. And I will say that the proposed, and I checked this morning, and we have not seen proposed rules from DOD, HHS, VA, or guidance from them, but that is something that we expect here. And the executive order understands that these restrictions could affect research entities because it does also direct the above agencies, all of which fund or conduct huge amounts of research around the world, to assist U.S. research entities in ensuring protection of their bulk sensitive personal data. So they're supposed to issue guidance that helps the regulated community understand how to protect their data. There's no timeline for the rulemaking called for by these agencies, but they do have to submit a report to the president by next February that detail their progress toward issuing regulations or guidance. Now, there's also a request, and this I think is relevant for this group if it focuses on research, that relevant agencies such as OSTP, HHS, the VA, the DoD need to submit a report to the president that assesses the risks and benefits of regulating transactions that involve certain types of human omic data other than human genomic data, such as human proteomic data, human epigenomic data, and human metabolomic data, and recommending the extent to which such transactions should be regulated. So the key point here today is that the DOJ regulations that have issued, they focus on human genomic data, among other types of sensitive data, and place limitations on human genomic data. What the executive order calls for is President Biden is saying, give me a report about whether we should extend the protections beyond just human genomic data to these other types of omic data. And that report is due to the White House at the end of June of this year. So as I mentioned earlier, the restrictions that we see today are really focused on genomic data, but that might change in the future. So I mentioned that the first concrete action we've really seen under this executive order has been this DOJ Advance Notice of Proposed Rulemaking, or ANPRM. So I'm going to spend the next few minutes going through in some detail what this DOJ ANPRM calls for and what it might mean for the research community. So just a brief background on administrative law in the United States. When an agency is creating a regulation, they frequently go through what's called notice and comment rulemaking, which means that they put out a proposed rule, and then the regulated community has the opportunity to comment on that proposed rule, and the agency has to consider those comments before it issues a final rule. Agencies have some flexibility in how they conduct this rulemaking process, as it's often called. And here what DOJ has chosen to do is publish what's called an advance notice of proposed rulemaking, an ANPRM. And what an ANPRM is a very preliminary draft where we don't actually have the final text of any proposed regulations yet, but rather we have a lengthy discussion of what the DOJ is thinking about based on the executive order, definitions of key terms, and then they ask over 100 questions in this document that was published in the Federal Register. They invite the regulated community to comment, to educate the agency on certain questions. And so that ANPRM issued on February 28th, those of you that were involved in the revisions to the Common Rule, the regulations on federal human subjects research that took place several years ago, that process also started with an ANPRM. So this is that same type of initial, very preliminary rulemaking. So the ANPRM is open for comment for 45 days, and that period ends on April 19th, so 1 week from today. That's when comments on the ANPRM are due. And the executive order directs the DOJ to publish a proposed rule within 180 days of the publication. So on or before August 26, 2024. That's when we'll have a proposed rule, which will probably be titled a Notice of Proposed Rulemaking, or NPRM. That'll be followed by another comment period. And then after that comment period, the government will consider the comments that come in on the NPRM, and that's when a final rule would issue. So we're really looking at late this year. I think at the earliest we would have a final rule. But this is the timeline that we're looking for. And there's not certainty about once they issue this proposed rule on August 26th, it's not clear, how long it'll be for comments or when a final rule might issue. So what is the general prohibition that's contained in this ANPRM? And so what the document states is, except as otherwise authorized pursuant to these regulations, that is the regulations DOJ is going to put out, no U.S. person on or after the effective date may knowingly engage in a covered data transaction with a country of concern or covered person. So in this one sentence, we have a lot of important defined terms that I've italicized that I'm going to go through on the following slides, because you have to understand what is a covered data transaction, what is a country of concern or covered person, to understand the scope of this prohibition. So starting with a covered data transaction, that is any one of 5 types of transactions that I list on the following slide. I'll go through those transactions in some detail. If the transaction involves any bulk U.S. sensitive personal data or government-related data. And we're going to spend some time today talking about what is bulk U.S. sensitive personal data, because that's key to understand. One other thing I want to highlight on this slide before we move on is note that word I have italicized, knowingly. And so this is not proposed to be a strict liability regime, but rather there's some type of knowledge standard that is imposed on the U.S. person who's engaging in this transaction, some knowledge standard that they're dealing with a country of concern or covered person. In the preamble to these proposed regulations, the Department of Justice states that they currently intend for the knowingly language here to apply to persons who knew or should have known of the circumstances of the transaction. In its guidance on what an individual or entity should have known in such context, the Department of Justice proposes to take into account the relevant facts and circumstances, including the relative sophistication of the individual or entity at issue, the scale and sensitivity of the data involved, and the extent to which the parties to the transaction at issue appear to have been aware of and sought to evade the application of these rules. It's not intended to be a strict liability standard. So I think one of the key things to watch as we move from advanced notice of proposed rulemaking to notice of proposed rulemaking is what the government says about that knowledge standard and any accompanying, diligence expectations that they may have with respect to these types of transactions. So thinking a little bit about these covered data restrict transactions that are going to now have limitations on them, the DOJ has really set up a two-part framework in this proposed rule. They are dividing these covered data transactions into two flavors, if you will. The first are certain classes of highly sensitive transactions that would be prohibited in their entirety. These are called prohibited transactions. No exceptions, these transactions are going to be prohibited. Then there are other classes of transactions that would be prohibited except to the extent that they comply with predefined security requirements. Those are restricted transactions. Now, spoiler alert, at the end of this section, I am going to talk a little bit about a licensing regime the DOJ is considering that would allow certain exceptions. So even if something is prohibited, there may be the possibility of a certain license that may make it acceptable in some narrow circumstances. I'll talk about that in a moment. But I think what's important to note here is that the government is saying there's two categories of prohibited transactions. And I think these types of transactions may be quite relevant to the research community. The first are data brokerage transactions. I'll talk a little bit on a subsequent slide about what that means. And the second is any transaction that provides a country of concern or covered person with access to bulk human genomic data or human biospecimens for which such human genomic data can be derived. So we see here the government would prohibit transactions that involve the sharing of bulk human genomic data or the biospecimens from which that data can be derived. And that is something new, and that traditionally in US privacy law, for example, the biospecimens themselves have not been regulated directly or at least explicitly. And now we're seeing here a restriction on the export of the biospecimens as part of these covered data transactions. With respect to restricted transactions, so remember, these are the kinds that are going to have restrictions on them with respect to specific security requirements. Restricted transactions include vendor agreements. So for example, if you're entering into an agreement for technology services or cloud computing services with a covered person, there'll be certain restrictions on that. Employment agreements, which might mean you're a US company, you have employees who are located in a country of concern or who are foreign persons or covered persons. Those employment agreements could have restrictions, and also investment agreements would have restrictions. And I'm not going to focus so much on the investment agreements today, given our research focus here. But essentially what the government's thinking about there is a person, a covered person who obtains direct or indirect ownership interests or rights in certain US real estate or a US legal entity. And examples they give are like a private equity fund from the People's Republic of China acquires ownership of a data center in the United States. That would be a restricted transaction, for example. If we go to our next slide, I'm going to talk a little bit about who are the covered persons. So remember, I talked about how the restrictions apply to the covered data transactions with covered persons or countries of concern. The countries of concern are listed here. I've already gone through them, but who is a covered person? That's important to understand. A covered person would be an entity that is 50% or more owned directly or indirectly by a country of concern, so by the government of that country of concern, or that is organized or chartered under the laws of or has its principal place of business in a country of concern. And so a company that's headquartered in the People's Republic of China, for example, would be a covered person. It also includes an entity that is 50% or more owned directly or indirectly by an entity that's described in this category 1 above I just went through, or a person described in these categories below on the slide. It also includes a foreign person who is an employee or contractor of a country of concern or of an entity described in the categories listed here. Or a foreign person who is primarily resident in the territorial jurisdiction of a country of concern. So let's say we have a French national who lives in Beijing. They're primarily resident in Beijing. They would be a covered person here. And then look at this last bullet here, number 5. The definition of covered person also includes any person designated by the Attorney General as being owned or controlled by or subject to the jurisdiction or direction of a country of concern, or is acting on behalf of or purporting to act on behalf of a country of concern or covered person, or knowingly causing or directing a violation of these regulations. And so in essence, we have two ways that people could become covered persons. One is they can meet these definitions 1 through 4 that are listed on the slide. Or secondly, they can be individually designated by the Department of Justice on a public list that the DOJ will maintain of people who are covered persons. But even if you're not on the list, if you meet one of these definitions on the slide, 1 through 4, you're going to be a covered person. But to provide some more clarity, the government's saying we're also going to publish a list of people that they deem to be covered persons under the law. Now, going to our next slide here. One thing I should note here on this is set up so that if, let's say, you have someone who's a citizen of the People's Republic of China, but they reside in the US, they would not be a covered person under the law. They would be treated as a US person, which means interactions between US persons and that, let's say, Chinese citizen living in the US, those wouldn't be covered data transactions. But that Chinese citizen living in the US, they're treated like a US person, meaning that any transactions that they engage in would have to follow the same rules as the rules that apply to other US persons. Now, what are the categories of bulk US sensitive personal data that the DOJ proposes to restrict? So there's 6 of these categories. They include covered personal identifiers, which are kind of traditional identifiers like social security numbers, government identifiers, government account numbers, personal financial data, personal health data, precise geolocation data, biometric identifiers, human genomic data, and any combinations of the above categories. So these are the types of sensitive personal data of US persons that the government is interested in protecting here. There's also, remember, government-related data that's covered. I'm not going to focus on that as much today because I think it's going to be less relevant for the research community. Note, and this next bullet in the middle of the slide is key. Maybe I should have bolded it actually, because there is no exception for anonymized, pseudonymized, de-identified, or encrypted data, although DOJ seeks comments on whether such an exception should be created. So this is very important to keep in mind because under a lot of data privacy laws, like GDPR even, there are exceptions if data are fully anonymized, or in some cases, there may be lesser protections if data are pseudonymized. But the DOJ's proposed rule explicitly say that there's not an exception from these definitions of bulk US sensitive personal data for de-identified, anonymized, or pseudonymized data. And I do suspect that's something that a lot of the regulated community in the research sector, at least, is going to be commenting on in this notice and comment rulemaking process. And then who is a United States person? That's a key question to understand because remember, the types of data that the government seeks to limit here, the sharing of, are data of United States persons. And the actions that they are limiting are transactions between United States persons and countries of concern or covered persons. So a US person is any United States citizen, national, or lawful permanent resident, any individual admitted to the United States as a refugee or granted asylum, any entity organized solely under the laws of the United States or any jurisdiction within the United States, so like a US state or territory, and any person located in the United States. And this last piece, any person located in the United States, is how I got to the remark I made a moment ago about if you had a Chinese citizen who lived in the United States, they would be treated as a US person under these regulations. I think it's also worth taking a moment. Remember, I said there's 6 categories of sensitive personal data that are proposed to be limited. I here highlight the definitions of the 3 that I think are going to be most relevant in clinical research. The first is human genomic data. Remember, I said there's genomic data or a category of prohibited transactions, and I'll say more about that in a moment. Human genomic data for purposes of the proposed regulation means the data that represent the nucleic acid sequences that comprise the entire set or a subset of the genetic instrument of a human cell, including the results of an individual's genetic test, as defined in GINA, and any related human genetic sequencing data. And one thing to note here is there's these bulk thresholds. Remember, this is a limitation on bulk data sharing. Well, what does bulk mean? Well, the government's asking a question about that. What should bulk mean? What is the size of data, the number of persons' data that we want to limit? So for genomic data, the government's proposing to set that threshold somewhere between 100 and 1,000 US persons. Then there's biometric identifiers. Biometric identifiers are the measurable physical characteristics or behaviors used to recognize or verify the identity of an individual, including facial images, voice prints and patterns, retina and iris scans, palm prints and fingerprints, gait and keyboard usage patterns that are enrolled in a biometric system and the templates created by the system. For this limitation, the government's proposing a bulk threshold of between 100 and 10,000 US persons. And then there's also a limitation on the sharing of personal health data. And for that definition, they turn to HIPAA. And they say the definition of individually identifiable health information under HIPAA would be the same definition of personal health data in these proposed regulations. But note that the limitations here would apply regardless of whether the information is collected by a HIPAA-covered entity or a business associate. And so the limitations apply to individually identifiable health information collected by any US person, regardless of whether they're covered by HIPAA or not, even though we're borrowing the definition from HIPAA. And for this category, the bulk threshold would be between 1,000 and 1 million US persons. And the government's seeking comment on what these bulk thresholds should be. And how do you measure the bulk threshold? What the proposed rule says, it would be measured for the preceding 12 months, whether through a single covered data transaction, so you might have one transaction with 1,000 US persons human genomic data, or aggregated across covered data transactions involving the same foreign person or covered person. So you might look at, we're sharing data with a covered person in China, and we've shared 1,000 biospecimens with them over the last year. That would be picked up by this definition. So I think it's worth taking a moment to just drill a little bit deeper on the two proposed prohibited transactions, because I do think they're quite important for the research community to understand. The first is the proposed prohibited transaction regarding human genomic data and human biospecimens. And let's just read this together for a moment. The text of the proposed prohibition says that, except as otherwise authorized pursuant to these DOJ regulations, no US person on or after the effective date, so we're looking forward, not looking retroactively, may knowingly engage in any covered data transaction with a country of concern or covered person, those are the types of people I just talked about, that provides the country of concern or covered person with access to bulk US sensitive personal data that consists of human genomic data or to human biospecimens from which such data could be derived, on greater than the applicable bulk data threshold. Remember, I said those are out for comment, but it seems like it's going to be between 100 or 1,000 US persons at any point in the preceding 12 months, whether in a single covered data transaction or aggregated across covered data transactions. So this is the general prohibition that the US is thinking of putting in place, which would limit the sharing of genomic data, let's say with covered persons that are companies that are organized under the laws of China, for example. What is the rationale for putting in place this prohibition? In the preamble to this proposed rule, the DOJ cites this National Counterintelligence and Security Center report that's explained the combination of stolen personally identifiable information, personal health information, and large human genomic data sets collected from abroad gives countries of concern vast opportunities to precisely target individuals and foreign governments, private industries, or other sectors for potential surveillance, manipulation, or extortion. So we really have this national security focus here that these genomic data, if shared with countries of concern or covered persons, could be used against the United States and threaten the national security of the country and its residents. Now, remember, there was a second category of prohibited transaction, and that was data brokerage. What does data brokerage mean? It's any transaction involves the sale of, licensing of access to, or similar commercial transactions involving the transfer of data from any person, the provider, to any other person, the recipient, that is a country of concern or a covered person. So we're providing data from a US person to a country of concern or covered person, where the recipient didn't collect or process the data directly from the individual linked or linkable to the collected or processed data. So meaning that that person in the country of concern, the covered person, they didn't collect or process data directly from the US individual who's the subject of the data. And so this is really to limit a lot of data licensing activities, data sale activities that might involve a country of concern or covered person. And notably, while most of the restrictions in this proposed regulation are between a US entity and a country of concern or covered person, this is one area where the government is placing some restrictions on transactions between a US person and a foreign entity that is not a covered person or country of concern. Because what they're saying here, if we don't want a situation where, let's say, a US entity transfers data to France, then the French entity turns around and transfers it to China. And so to limit those types of onward transfers, what the US government proposes to do here is say, except as otherwise authorized under these regulations, no US person on or after the effective date may knowingly engage in a covered data transaction involving data brokerage with any foreign person. So that would be somebody located outside of the United States, regardless of whether they're in a country of concern or not, unless the US person contractually requires that the foreign person refrain from engaging in a subsequent covered data transaction involving the same data with a country of concern or covered person. And there's a nice example here in the regulations focused on genomic data. They say a US business knowingly enters into agreement to sell bulk human genomic data to a European business that is not a covered person. The US business is required to include in that agreement a limitation on the European business's right to resell that data to a country of concern or covered person. And so this is how the government tries to limit onward transfers of genomic data, for example. On the next slide here, I note that there are certain types of data that are exempt from the DOJ regulations. And there's this official business exemption that's talking about official business of the United States government. And this discusses transactions conducted pursuant to a grant, contract, or other agreement entered into with the United States government. And most notably, the exemption would exempt grantees and contractors of federal departments and agencies, like the US Department of Health. So let's say awardees of an NIH grant, the Department of Veterans Affairs, the National Science Foundation, and the US Department of Defense. An example given here is a US hospital that receives a federal grant to conduct research on US persons. As part of the federally funded human genomic research, the US hospital contracts with a foreign laboratory that is a covered person, hires a researcher that is a covered person, and gives the laboratory and researcher access to the human biospecimens and human genomic data in bulk, so above those thresholds we talked about. The contract with the foreign laboratory and the employment of the researcher would be prohibited covered data transactions if they were not part of the federally funded research. So remember, back to the executive order I talked about at the beginning, President Biden instructed HHS, DOD, the VA to issue their own regulations. And so what is posited here is that the federally funded research is going to be subject to the regulations issued by HHS, DOD, VA, whoever the funder is of that research. It's not going to be subject to these DOJ regulations. But this also means, if we look at the last sentence, where it says the contract with the foreign laboratory, the employment of the researcher, would be prohibited covered data transactions if they were not part of the federally funded research. Well, that means that if it's privately funded research, then this would likely be a covered data transaction that would be prohibited by the regulations because it involves human genomic data. So that's important to keep in mind. There's a great differentiation in this proposed DOJ rule about how federally funded research would be treated versus privately funded research, because the expectation is that federally funded research will be subject to rules from the awarding agencies, whereas privately funded research would be subject to the DOJ's regulations. Now, I said there's over 100 questions on which the ANPRM solicits comments. I highlight a few here related to genomic data because I thought they might be of a special interest to this audience. The first question is, what will be the economic impact of prohibiting any covered data transaction that provides a country of concern or covered persons with access to bulk US genomic data and human biospecimens from which that sensitive personal data can be derived? The second question is, what sectors are involved in access to bulk US human genomic data and human biospecimens? Are there any sectors that involve access to one, but not both of these categories? They want to hear about the size of the markets and what types of commercial transactions involve human genomic data and human biospecimens. So again, the government is interested in hearing feedback from the regulated community on this. And part of this is because as part of the rulemaking process, the DOJ is going to have to put together a section of their proposed rule or their final rule that talks about the potential economic impact on the United States. And so this is the time to comment on these by next Friday on the ANPRM or later this summer on the notice for post-rulemaking. Now, remember I said there's these genomic data transactions, data brokerage transactions that are prohibited, but I had hinted that there might be some exceptions that would be available. Well, the DOJ does propose to create what they call a licensing regime here, where they would have what are called general and specific licenses that would improve or impose conditions on covered data transactions that are prohibited or restricted. It would include any interagency consultation process to ensure that agencies with relative equities and expertise may weigh in here. And so general licenses would be authorizing certain types of covered data transactions that are otherwise prohibited or restricted under the requirements contained in the rule. So this essentially would be saying the DOJ is going to set forth certain rules, for example, that might allow certain types of human genomic covered transactions to take place, covered data transactions, that is, to take place. And then there are also specific licenses which authorize a particular entity to conduct a specific transaction that otherwise would be prohibited. So the general licenses would set forth general rules. The preamble talks about how it will give the department flexibility to exempt, alter the conditions for, or allow wind down periods for certain categories of otherwise regulated transactions. Specific licenses, on the other hand, are going to be like for a specific transaction, and the DOJ is supposed to make these licensing decisions in concurrence with the Department of State, Commerce, and Homeland Security. As far as the timing here, like I said, again, we have no idea when a final rule, if a final rule will issue, when it will issue, but it would be at the earliest be late this year. But the DOJ is currently considering creating and implementing a compliance and enforcement program that's modeled on the Department of Treasury's economic-based sanctions, which are administered by OFAC. Many of you may be familiar with that already. The program that DOJ is creating won't apply retroactively. That is before the effective date of the final rule. Again, we don't know what that effective date will be. However, the DOJ may, after the effective date of the regulations, request information about transactions by U.S. persons that were completed or agreed to after the date of the issuance of the order to better inform the development and implementation of the program. And so we are now going to turn to some of the congressional activity in the space, but I think I may take a few of the questions that we've gotten on the ANPRM. The first question is, how would the proposed regulations impact those organizations which are subsidiaries in the US of foreign companies concerning personal employee information and sharing clinical trial data information within their teams who may be located in one of the identified countries? And so I think here you'd have to look at the limitations on sharing of employee data and also the limitations on how the covered person is defined. Remember, it's a very specific definition, who is a covered person, and it generally doesn't apply to people who are located in the US. So people who are located in the US wouldn't be considered covered persons. There's not limitations on sharing of data with them. But I think it is going to be important for entities to pay attention to the sharing of data amongst their entities. And there's also certain exceptions for certain business activities and the rules that I didn't go into today because we didn't have time to do that, but that is going to have to be a careful analysis. And then there's a question here about whether it's correctly understood that proposed rules would apply to clinical trial data that are used for regulatory purposes. And I think that is a good question, that the data are going to be, let's say, genomic data sets are going to be shared with Chinese authorities. Well, the regulatory authorities in the PRC are part of the government of the PRC. They are a country of concern, or they could be considered covered persons. And so it may have effects on the ability to share data of US persons with regulatory authorities in countries of concern. And I expect that might be one area where the DOJ considers having some type of licensing exception. They're seeking comments on lots of things. And I know that is something that a lot of entities in the clinical research space are thinking about commenting on. And then I think there's another question that says, just clarifying that clinical trial data include both personal identifiers and personal health data. And yes, because there's no exception for de-identified data here. The information that's provided, even though it might be encoded or pseudonymized form to a foreign regulator, could very much be in scope for these DOJ proposed regulations. So what we've been talking about so far has been action of the executive, action of the Biden administration through an executive order and proposed rulemaking. Now we're going to turn our attention to Congress. What has Congress been up to recently? So the first thing I'm going to talk about is the Protecting Americans Data from Foreign Adversaries Act. So this act was introduced in the U.S. House on March 5th of this year by the Energy and Commerce Committee ranking member Frank Pallone from New Jersey and the Ethics and Commerce Committee Chair Kathy McMorris Rogers from Washington State. On March 7th, so it was introduced March 5th, 2 days later, this committee voted 50-0 to report the legislation to the House floor for the full House to vote on. And on March 20th, the House voted 414-0 to pass this piece of legislation, which is almost unheard of in this day and age to have unanimous legislation like this passed so quickly. It was only 15 days from introduction for the legislation to be passed by the House. It's now moved on to the Senate. But we do not know exactly how the Senate, whether they will take this up at this point. And I have a slide on that goes into more detail. But this is one area that the United States Congress seems very united on putting certain limitations and protections in place. So what would this law do? Well, this bill would make it unlawful for a data broker to sell, license, rent, trade, transfer, release, disclose, provide access to, or otherwise make available the personally identifiable sensitive data of a United States individual to the People's Republic of China or other countries of concern. A slightly different list here: Russia, North Korea, and Iran. We don't have Venezuela or Cuba on the list, or any entity that's controlled by those countries. Unlike the DOJ and ANPRM, also, while the bill refers to the PRC, it doesn't specifically include Hong Kong or Macau, and also doesn't have Cuba or Venezuela, as I mentioned. The bill here is defining United States individuals, so this is concerning the data of United States individuals, as a natural person who resides in the United States. So again, this is something that might pick up foreign nationals who reside in the United States. They'd be treated as U.S. individuals under this law. And so the limitation here, remember, is on sharing data with foreign adversaries. So what is a foreign adversary? So that would be the government of the foreign country or entities that are controlled by those countries. So an entity is controlled by a foreign adversary, that is controlled by the PRC or by Russia, if the entity is a foreign person that is domiciled in, headquartered in, has its principal place of business in, or is organized under the laws of a foreign adversary country, or that's owned directly or indirectly by a foreign person described above with at least a 20% stake, or a person subject to the direction or control of a foreign person that's described above. Importantly, while this sounds similar to what I just talked about under the DOJ and ANPRM, the ANPRM focuses on entities at least 50% owned directly or indirectly by a foreign person, which is a higher threshold than what we have in this legislation. In other words, this legislation might sweep in additional entities because it has this 20% ownership stake limitation. And data brokers are entities. What are these data brokers that are limited under this law? They're entities that make available data of U.S. individuals, which are natural persons residing in the U.S. Remember that the entity did not collect directly from such individuals to another entity that is not acting as a service provider. And so there are certain exceptions here, like if the data are transmitted to the entity, the foreign entity of concern, if it's at the request of the individual. It's also an exception if the product or service that's being offered is not actually the data itself, but it's another product or service. There's not a lot of color on what this means, but this might, for example, be helpful if we're thinking about providing an investigational product where, like, we argue what we're providing in the clinical trial is that product and not specific data or services. There's also an exception to make available news or information that's available to the general public, and also an exception for service provider arrangements in certain cases. So the DOJ ANPRM also proposes prohibiting data broker transactions. It uses similar language to define a data broker, but without the specific exemptions that are provided for in the bill. And so, in other words, this legislation has some exemptions here that the proposed rule I just talked about don't have, like this exception for service provider relationships. Sensitive data. What are sensitive data under this law? It's more expansive than the definition of sensitive personal data that we find in the DOJ regs. And remember, the DOJ regs have these numerical limitations, those thresholds to make it bulk sensitive personal data. The Protecting Americans Data from Foreign Adversary Act does not have this bulk requirement. Instead, it just is talking about any sensitive data, including healthcare information, biometric information, genetic information, sexual behavior information, an individual's race, color, ethnicity, or religion, online activities, and military status. I bolded these because I think these are most relevant for the clinical research community. And then there's a bunch of other different types of sensitive data that are included in this law. The bill would also propose to treat a violation of the bill as a violation of a rule defining an unfair or a deceptive act or practice under the Federal Trade Commission Act. So the FTC, the Federal Trade Commission, which as many of you may know, enforces certain privacy legislation in the United States, they would be in charge of enforcing this under their authority to regulate unfair or deceptive acts or practices. So we wouldn't have this kind of like economic sanctions-based regime that the DOJ is thinking of setting up under its proposed regulation. There's also not, remember at the end of my discussion of the ANPRM, I talked about the licensing regime under which there might be certain exceptions to the prohibitions. This bill, the Protecting Americans Data from Foreign Adversaries Act, doesn't have any of those types of exemptions. And it takes effect 60 days after its enactment. Now, remember I said that this passed the House unanimously, but that doesn't necessarily mean it's going to become law, because if we look at my schematic, and some of you might remember back to school how a bill becomes a law, Schoolhouse Rocks, we first had the legislation pass the House committee, then it passed the full House, but in order to become law, it would have to pass the Senate Commerce Committee, pass the Senate, and be signed by President Biden. The bill has now been sent to the Senate Committee on Commerce, Science, and Transportation. But there's no guarantee that that committee will take it up swiftly or at all. A majority leader Schumer and the chair of the Senate Commerce Committee, Senator Cantwell from Washington State, have not indicated whether they are going to support the bill. So I think there's a question mark remaining about whether this is actually going to become law, but still important to know. Now, if we go to our next slide, I'm going to pivot from these executive actions and legislation that were focused on Americans' data to another piece of legislation, the BIOSECURE Act, that also has potential implications for the American research enterprise and its arrangements with certain countries of concern, the BIOSECURE Act. But the BIOSECURE Act is not so much focused on data sharing, or at least not explicitly, but rather on the awarding of government contracts to entities that do business with certain biotechnology companies of concern. So to recap, this legislation was introduced at the end of last year. There were 2 senators that introduced it bipartisan support. On March 6th of this year, the Senate Committee on Homeland Security and Governmental Affairs voted 11-1 to report the BIOSECURE Act to the Senate floor. And the bill has 7 co-sponsors. Notably, the one person who voted against it in Senate committee was Senator Rand Paul. Then the U.S. House has also taken action on this legislation. On January 10th, the House voted to establish the Select Committee on the Strategic Competition between the United States and the Chinese Communist Party. And on January 25th, the chair of the Select Committee, Representative Mike Gallagher from Wisconsin, and Ranking Member Representative Raja Krishnamurthy from Illinois, introduced the BIOSECURE Act, and it has 7 co-sponsors. Now, what would the BIOSECURE Act do if it were enacted? Remember, this is proposed legislation, and making things even more confusing, we have competing versions of this bill now, because we have the version that emerged from the Senate markup, the Senate committee's markup back in early March, and then we have the version that was initially introduced and that is still the House version of the bill. And I'm going to talk a little bit about some of the key distinctions between those two. So you have to keep in mind when talking about this legislation, it's proposed, so it might change, and we have multiple versions that have some key distinctions between them. But in general, the bill would prohibit executive agencies, so that's like the Department of Health and Human Services, the Department of Defense, from contracting with or extending loans or grants to any entity that has certain arrangements with a biotechnology company of concern. What is a biotechnology company of concern? Well, in general, it's a company that's headquartered or subject to the jurisdiction of a foreign adversaries government, which in this case is the PRC, Russia, Iran, and North Korea, and then imposes a threat to the national security of the United States. The bill specifically names certain companies related to the PRC. Those are BGI, MGI, Complete Genomics, and WuXi AppTec, and their subsidiaries, parent affiliates, and successors. These are all explicitly named biotechnology companies of concern in the proposed legislation. So what does the legislation do? It says that an executive agency, which as I said includes HHS, DOD, and several others, may not. And this is where we have some divergence between the originally introduced version of the legislation, which is still the House version of the bill, and the Senate marked up version of the bill. If you look at congress.gov, you're going to see this introduced version. And to find the Senate marked up version, you have to actually go and do some hunting on the committee page of the committee that marked up the bill. So it's a little bit hard to find, just word of caution for you going to do some research on this. But the introduced version, what the prohibition there is so that agencies like HHS could not procure or obtain any biotechnology equipment or service produced or provided by a biotechnology company of concern. And I'll talk about what a biotechnology equipment or service is on the next slide. Or, and perhaps more importantly, these agencies can't enter into a contract or extend or renew a contract with any entity that uses biotechnology equipment or services produced or provided by a biotechnology company of concern and acquired after the applicable effective date in performance of the contract. So that means these entities can't use the biotechnology equipment or services provided by the biotechnology company of concern. So biotechnology equipment or services provided by WuXi, for example, that can't be used in the performance of the federal contract. Or if we look at the left-hand side of the slide in 2B, they can't enter into a contract the performance of which will require the direct use of biotechnology equipment or services produced or provided by a biotechnology company of concern and acquired after the applicable effective date. What does that mean? It means that HHS, DOD couldn't enter into a contract with an entity that itself has a contract, the performance of which requires the direct use of biotechnology equipment or services produced by a company like WuXi that's a biotechnology company of concern. Note, under this introduced version, there's not an explicit tie between the use of that biotechnology equipment or service and performance under the federal contract. So let's say NIH couldn't award funds, grant funds, or contract funds to an entity that has a contract with WuXi for biotechnology equipment or services, even if that contract is not related to the federal award. And this is one place where the Senate version, the marked up version, takes a different approach. If we look at the right-hand side of the schematic, what's different in the Senate marked up version is it says that HHS, DOD, these other executive agencies can't enter into a contract or extend or renew a contract with an entity that uses biotechnology equipment or services produced by a biotechnology company of concern in the performance of their contract with the executive agency, or that enters into any contract the performance of which such entity, so the entity receiving the federal funds, knows or has reason to believe will require in performance of the contract with the executive agency. And that's key limiting language in performance of the contract with the executive agency, the use of the biotechnology equipment or services. So this would be a narrower prohibition because it's saying, let's say NIH can't give an award to a university that is going to use a contract with one of these biotechnology companies of concern in its performance of the NIH award, as opposed to saying if that university has an arrangement with WuXi wholly separate from its federal awards, that there'd be a prohibition. So this is going to be a key thing to watch as the legislation, if the legislation moves forward, which of these versions are adopted, or maybe it'll be something else. So remember, this is about restrictions on contracts with biotechnology companies of concern. Again, BGI, MGI, Complete Genomics, and WuXi AppTech are the four named entities, along with their subsidiaries, parent affiliates, and successors. It also includes an entity, so biotechnology company of concern also includes entities that are subject to the jurisdiction, direction, control, or operation on behalf of the government of a foreign adversary. That's involved in the manufacturing or distribution of a biotechnology equipment or service. And so this is a key definition, because remember, the limitations are all about the use of biotechnology equipment or services from a biotechnology company of concern. And biotechnology equipment or services are any instrument or service that is used in research, development, production, or analysis related to biological materials, including software, data storage, consulting services, support services, and disease detection services. And to be a biotechnology company of concern, in addition to meeting these first two elements, you also have to pose a risk to the U.S. security, either by engaging in joint research with or being supported by a foreign adversary's military, or by providing genetic data to a foreign adversary's government, or by obtaining multi-omic data without express and informed consent. Exceptions. And so there are some exceptions in the law where the executive may waive the bill's restrictions on a case-by-case basis with the Office of Management and Budget approval for no more than 365 days, with an option for the OMB to extend this by an additional 180 days. Also, contracts or transactions for the provision of healthcare services overseas may be subject to an exemption as long as the service is necessary to support an executive mission. This might be thinking about, diplomats living abroad and what would be possible with respect to contracts for services with respect to those individuals. With respect to enforcement timing, if this legislation were to pass, and remember, it's all proposed and we have multiple competing versions of the legislation right now, but BGI, MGI, Complete Genomics, and WuXi AppTech would become restricted either 120 days after enactment of the act or 60 days after the OMB issues an implementing guidance, whichever comes first. So the legislation does call for the Office of Management and Budget, OMB, to issue certain guidance about the law and how it's being implemented. Other biotechnology companies of concern, so those who aren't named in the bill, but that might meet the definition that I had in the last slide of biotechnology company of concern, those would be listed by OMB within 120 days after the date of enactment, and they would become restricted 180 days after OMB issues its guidance. And OMB is going to be periodically reviewing and updating its list of biotechnology companies of concern as it deems appropriate. So new companies can be added to the list. This is another area I didn't go into a lot of detail on the slides, but where the House version and the Senate version of the Senate markup, I should say, version of the bill diverge. The Senate version has a much more robust process for adding companies to this list and has some ability for those companies to be put on notice and potentially object to being on the list. So again, that process for adding companies to the list is something that is different between the House and Senate markup version of the bill, and something that I think is going to be important to watch as this legislation moves forward, if it moves forward. The revised Senate bill also contains a grandfathering provision, which states that for biotechnology companies of concern, the restrictions in the bill wouldn't apply to biotechnology equipment or services that are produced or provided under a contract or agreement entered into before the effective date of the prohibition on that company becoming a biotechnology company of concern. So essentially what that means is there might be some grandfathering if the Senate markup version of the bill were to become law. There could be some ability for existing contracts with companies like WuXi to go forward. However, there are some interesting questions that arise about what if it's a master services agreement one has with a company like WuXi or another biotechnology company of concern, but there's new statements of work or purchase orders that are entered under that master services agreement. And the legislation is silent on that. It's not really clear whether it would be looking at whether the contract, the MSA, was entered before the effective date, or if it would be thinking about whether the purchase orders and SOWs themselves would have to be entered before that effective date. And I suspect that's something that the guidance that's called for under the legislation might speak to. Now back to our little schoolhouse rocks diagram about the BIOSECURE Act. What are its prospects for passage? Well, this one would need to pass the Senate. It would need to pass the House committee. It would need to pass the House and be signed by the president. So all that's happened here so far, as far as movement of the legislation, is passage by a key Senate committee, but it still has to go through these other steps in order to become law. In the Senate, Senator Schumer, the majority leader, hasn't indicated whether he's going to bring the act to the Senate floor. And remember, the ranking member of the committee in the Senate that considered this, Rand Paul from Kentucky, voted against the bill in committee. In the House Committee on Oversight and Accountability, Chair Representative James Comer from Kentucky, he's not indicated if he's going to bring this up for a committee vote. And one other notable thing is that Representative Gallagher from Wisconsin, who was the person who was really spearheading this legislation, the key sponsor of it, he's retiring early from Congress a week from today. And so a key advocate for the law is leaving the House at this time, and so unclear what that means for passage of the bill. One other thing to note here is there's a lot of discussion in the trade press recently about concerns of the pharmaceutical industry, pharmaceutical manufacturers, about the potential impact of the BIOSECURE Act on supply chains, because these companies, be they American companies or European companies, may depend on entities that are biotechnology companies of concern for manufacturing of their products. And so concerned that manufacturing of drugs might be impaired if the BIOSECURE Act were to become law. An article that was published in BioCentury magazine last week reported an interview with the CEO of a biotechnology innovation organization, BIO, the trade group for many pharmaceutical manufacturers, that highlighted some of these concerns about supply chain and efforts to make Congress aware of them. But the geopolitics here are quite interesting if you've been following it, because BIO, as an organization, originally opposed the BIOSECURE Act, and it came under some criticism from Congress for opposing the legislation. And when BIO's new CEO Crowley, took his position a few weeks ago, BIO changed its position and now supports the bill after initially opposing it. If you read this BioCentury article, I think it's quite interesting. It has an extensive interview with CEO Crowley, and he's talking about how reversing the position of BIO on the BIOSECURE Act gives BIO a seat at the table to make Congress members and policymakers educated about the concerns that would happen if these supply chains were disrupted. But it also, CEO Crowley calls for thoughtful systemic decoupling necessary to end U.S. reliance on Chinese biotechs. So it's been interesting to watch how positions have changed as this legislation has moved forward by some key stakeholders. So some last thoughts here. I know this has been a lot of information in a short time, but the executive order, the DOJ and ANPRM I talked about, and the Protecting American Data from Foreign Adversary Act would all, if those regulations are finalized and if this act is enacted, would require careful attention to flows of data and biospecimens from the US to the People's Republic of China and other countries of concern. I think it's notable to pay attention to the comment periods on the DOJ rulemaking. As I said, a week from today, the comment period closes on this ANPRM, but then there's likely to be another comment period late in the summer, starting in August when the proposed rule comes out. So that's something that I think you'll want to pay close attention to. In the notice of proposed rulemaking that issues in August, the government is going to talk about what type of comments are received on the ANPRM and how it addressed them in shaping the notice of proposed rulemaking. And it's important to keep in mind, those of you who followed the multi-year rulemaking for the common rule know that there are often significant changes between what's initially proposed and the final rule that emerges. And often those changes, as it was with the common rule, are driven by comments provided by the regulated community. That's why we have notice and comment rulemaking, so that the government puts the regulated community on notice of what the rule might be, and there's a chance for comment that can shape the rule. So I draw that to your attention that it's just important to pay attention to the rulemaking process and consider whether you want to comment on the proposed rules, either at this stage or at the later stage at the end of the summer. With respect to the BIOSECURE Act, Again, we don't know if this is going to become law, and I just noted that there's some reasons it may not become law, but it requires really evaluation of arrangements with biotechnology companies of concern or companies that may in the future be labeled biotechnology companies of concern. One thing some clients have been doing is considering whether the contracts they have with biotechnology companies of concern or new contracts with them should provide for termination rights if the U.S. company determines that the contract may violate U.S. law. Let's say if the BIOSECURE Act is enacted, the company may want the ability to terminate that contract rather quickly, or if the ANPRM is enacted in its current form. And lastly, as I mentioned already, if you missed the comment period that closes next Friday, April 19, on the ANPRM, you'll likely have a chance to submit comments on the notice of proposed rulemaking when it's published. And you should also keep an eye out for a separate rulemaking process from the Department of Defense, HHS, the Veterans Administration, and the National Science Foundation. If you're sending comments on the DOJ ANPRM, you may want to review those, and once we have proposals out from these other agencies, you may shape those comments into comments to those agencies. So I think a key thing is to stay on the alert, keep watching the Federal Register public inspection docket where they put out the proposed rules before they hit the Federal Register. Just keep watching that over the coming weeks and months, because there is surely, or likely, I should say, to be additional action from these other agencies. One other thing completely separate that I'm going to note is, while I talked about how this is national security related legislation, not data privacy legislation, we did have comprehensive privacy legislation that was introduced earlier this week in the federal government that has sponsors from both the Republican and Democratic parties. And that law, the text was just released this week, but that shows that the federal government, even setting aside these national security considerations, is also considering comprehensive data privacy legislation inspired by GDPR and some of the state privacy laws we have in this country. That's something else to keep abreast of. So no dull moment today, never a dull moment when it comes to data privacy or national security and research. So that's the end of my prepared remarks. I see we have a few questions here that have come in. I'm going to bring them up now and take them one by one. So we have a question saying, I think they're talking about the DOJ ANPRM, or the Protecting American Data from Foreign Adversary Act, that says if you buy data, you must ensure that it's not from or going to China. Well, the limitations here are really not on data coming from China with respect to the DOJ ANPRM or the Protecting Americans Data from Foreign Adversaries Act. They're really about the sharing of data of U.S. persons with China or other countries of concern or covered persons. So I think what you're really going to want to do is analyze data flows to see if data that are sensitive personal data of U.S. persons under either the DOJ regulation or the Protecting Americans Data from Foreign Adversaries Act, if those are finalized in their current form, you'd want to do data mapping to figure out, what data flows are going to countries of concern that would have to be changed. With respect to the BIOSECURE Act, there's, again, that's not focused on buying data so much, but it is focused on contractual arrangements one might have with a biotechnology company of concern. So that's something else companies will want to be attuned to. Our next question is about, in the clinical trial context, U.S. persons covers U.S. citizens who may live outside of the U.S., correct? If such a person was a participant in the trial, the pharma sponsor would not know they are a U.S. citizen, only the location of the clinic in the pseudonymized data. And again, that goes back to that definition of U.S. person, and that varies, from one law to another. But generally, you're right that it focuses on U.S. citizens, and so there may be some questions that come here, and that's something to pay attention to in the rulemaking that as it advances. And then there's a question about how the rules would impact data sharing platforms that post anonymized research data. I mean, again, I think that's something that one is going to have to watch carefully as the rulemaking develops, because there's not a clear exemption here for anonymized data in the DOJ ANPRM. It may have impacts on the sharing of data, research data, even anonymized data, with entities that are covered persons or that are located in a country of concern. I think that's all the questions that we've received here. If there's any additional questions, I'll hang on 30 seconds here and we can see if anybody wants to ask an additional question.
Thank you, David.
There's one more question that came in here. Curious on your thoughts for pharma sponsors that handle data transfer for reuse after the trial for creation of data products and development, use of AI, machine learning applications toward healthcare within China and Hong Kong. also considering upcoming laws such as the European health data space. Well, that's quite a complicated question. But I think in general, what I would say is that there's going to be data of US persons that are being transferred to China or Hong Kong. You're going to have to watch those data transfers carefully in light of the DOJ, ANPRM, and then any other regulations that are issued by federal funding agencies, and determine whether those transfers can continue to take place after the regulations take effect, and also if they can continue to take place, what restrictions need to be placed on those regulations or on those data flows. I think those are all the questions.
Thank you so much, David. That was so informative. I learned a lot. In terms of data platforms like Vivly, are we primarily concerned with genomics data, or is the aperture opened to concern with other types of data from these countries of concern?
Yeah, so I'd say two things there. Genomic data under the DOJ and PRM, genomic data are definitely front and center because they're considered a prohibited transaction. So under the proposed rule, the providing of those data would be prohibited if it's going to a covered person or country of concern. With respect to other types of clinical trial data, if they are considered other types of sensitive data, there may also be restrictions on them. So for example, if it's personal health data, there may be restrictions on those data being shared as well. It may not be a prohibited transaction, though. It may be subject to more restricted transaction framework, but that's definitely something to keep an eye on. And I think it's telling that the definition of these different data types doesn't exclude de-identified or anonymized data.
Well, thank you so much for your time today. That was very clear, and we very much appreciate your time.
It's my pleasure.
Willingness to answer questions as well.
Of course.
Absolutely. Well, that closes our webinar, and thank you again for being here, David.
My pleasure. Thank you, Rebecca.
Absolutely. And have a good weekend, everyone. Thanks again.